Welcome to Conflict to Clarity in Family Matters with Rahul Kishore.
Welcome back to Conflict to Clarity in Family Matters with Rahul Kishore. Rahul is a Maryland family law attorney with more than 30 years of experience helping individuals navigate divorce, custody, and complex financial issues. With a background in finance and an MBA, he takes a practical, cost-effective approach to resolving family law matters. I'm LeAnn Lyon, and today we are talking about the family home in a Maryland divorce and the options couples typically consider. It's good to see you again, Rahul.
Oh, and it's really nice to see you again.
Right. So, first of all, how is the family home addressed in a Maryland divorce?
Well, let's say this, LeAnn. It is one of the most important assets that any couple usually has in a divorce. It is the pivotal part of negotiating, mediating, and settling the divorce case. Obviously, it's the largest asset. It's the largest, most important thing. It's the most emotionally connected thing that these parties have, that they have built during the marriage. So in Maryland divorce, we have to take a very careful approach on how to handle the situation because emotions are very high, as you know, LeAnn. So it is a very important thing, and we do handle that aspect of it, and it is something that we as attorneys have to consider in giving advice on how to pursue that in throughout the divorce process.
So, what are the typical options that couples consider when deciding what to do with the house?
Well, let's put it this way, LeAnn. There's usually only one of three options normally. One is you sell the house, and you normally the parties do split the proceeds unless there's what we call a monetary award that one party gets, but normally the court does split the proceeds if there's any proceeds. That's the uh, first option, obviously. The second option, LeAnn, is that one party buys the other party out. Either party can buy the other party's interest in the property and transfer the title to the party who buys the interest out. The third option is what we call use and possession. What that means is that the property itself, LeAnn, stays in the name of both parties for a certain period of time, from 1 to 3 years normally is what the court can order, and otherwise it can stay in both parties' name for a longer period of time, and we call that use and possession. And that is for the benefit of the children, that the statute is there with the use and possession statute. And so that is an agreement where the parties keep the property in both people's name. It's titled in both people's name. And then after the use and possession period, the parties then have the option to do what you could do initially during the divorce, which is you sell the property, or you one party buys the other party out after the use and possession period.
So, what factors influence whether one spouse keeps the home or the property is sold?
Well, that's what we call the first factor is the use and possession. And if you go to court and the parties don't resolve the issue whether that they both agree to sell the property or one party buys the other party out, the issue of the use and possession goes in front of the court, and the court determines whether it is pivotal for these children to keep their surroundings and benefit them due to the separation of the parties, and that emotionally, physically, in all aspects of their development, that this house is important and the party should keep it so that the children can transition out of this divorce situation and keep their stable environment during the several years after the divorce. So the factors that they look at, I can tell you this: if both children are, let's say, babies, the court's not going to find it very important that they have a use and possession of let's say, a 2-year-old and a 3-year-old. But the time that it's very critical, LeAnn, for the court to feel that it's important that the use and possession period be given is, like, for instance, if the parties are, the children are, let's say, 14 and 16 years old, and they're going to be staying in the same house. They're used to the environment. The environment is important for their emotional development, and that it's important for them to transition during this period. Let's say they're in high school, to stay in this house until the parties or the children graduate from high school. So in my example, if I tell you one child is 14 and one is 16, the use and possession period may be extended for more than 3 years to 4 years, so that the second child could graduate from high school as well. But what's important to understand is that both parties have to understand that, because the statute in Maryland only allows the court to grant a use and possession period for up to 3 years from the date of divorce. They don't have the authority to do it more than 3 years.
So at that point, if 4 years is needed, who has the authority to set that up, or how does that work?
That would be, the authority would come from the parties mediating and coming to a settlement between themselves and signing a separation and property settlement agreement, saying that they're going to keep the use and possession period for up to 4 years. And a lot of parties, when they understand what's going on and they understand the law, most parties, if they're already going to know that they might be in a situation where the court's going to give it to them for 3 years, the party who gets custody of the children, then the other party normally would say, okay, one more year, it benefits the younger child. Let's, agree to that.
Okay.
So that's what normally happens. But this is all for the benefit of the children. And that's what the statute's for.
So how does a buyout work then if one spouse wants to keep the house and they're not going to do the use and possession?
Okay, so the important thing, as you know, LeAnn, right now we are in an environment where the interest rates have been going up, if you know that, over the last several years. If the interest rates are going down, it's a lot easier to do what we call a buyout. The reason being is, if you're refinancing a property, and the factors that you got to really look at carefully, LeAnn, is that whoever is buying out the other party's interest in the home, they have to be able to qualify on their own and put the mortgage, whatever the balance of the mortgage, in their own name. And the difficulty we have over the last few years is that the interest rates have been going up from, let's say, 3.5 to 6.5, 7%. And if you are a party going through a divorce at this time, you, number one, have to be able to have enough income to qualify based on the balance on the mortgage. And then number two, you have to be willing to take a higher interest rate and buy out the other party in being able to do the buyout. That's how the buyout works, is the party that's getting bought out definitely would want his or her name to be taken off of the mortgage. And the reason why that's important is because you don't want to be under the same, being liable for a mortgage. If I'm getting bought out, I don't want to be liable for a mortgage, LeAnn, where I wouldn't be able to qualify for another mortgage in the future, because the credit on that mortgage is still there, if you understand what I'm saying. And also, you're tying your the credit worthiness of the other party being able to pay the mortgage in the future. So if I'm getting bought out, I definitely want my name off the mortgage.
Absolutely. Absolutely. And I have a background with real estate as well. So yes, I
Okay.
hear everything that you're saying here. So how does the value of the home get determined during a divorce?
Well, LeAnn, what happens is, a lot of the people, if they both come to an agreement that, okay, we saw the house next door, it sold, and the other one down the street sold, and we think that, we can agree that this house is worth $650. Well, they can agree and do that. But if they don't, and one party says, oh, we made some improvements and I think it's worth $800,000, and the other spouse says, no, I think it's still maybe $675 at most. well, there's a disparity. So the simple process is you get a evaluation on it, a fair market assessment, and you hire an appraiser. And we do that all the time. And then the parties negotiate. Well, if one party is trying to, pick their appraiser, and they think that their appraiser is going to come in closer to them, then what happens is if they get into that much of a detail of arguing with each other, each party will have to pay for their own appraiser, and then sometimes we divide the amounts between the two appraisals. But that's only when you have a very contested case, LeAnn. But otherwise, parties normally agree to an appraiser, and we come up with the valuation, and that's where it goes from there. What I'd like to explain to you for another minute, if you don't mind, LeAnn, is the when you do a buyout. I'm going to give you an example because it's important for the listeners to understand, is that if the appraiser comes in and says the house is worth $500,000 as an example, and your mortgage that's left on the house is $300,000, okay? So there is $200,000 of what we call equity in this house. So if I'm buying out my spouse, I would not pay her $100,000, which would be half of her interest. What I would argue, depending on what side of if you're being bought out or you're buying out, is I would tell her attorney and my wife is that I'm going to take, let's say, 5 to 8% off of the appraised value. So let's say it's 8%. 8% of 500,000 is about $40,000. And the reason I would say that, it's 8% might be on the higher end, it might be 5%, 6%. And the reason why I'm arguing the 5, 6, 7, 8% is because I'm going to argue that if we sell this house, you're going to lose about 8% because of real estate commissions, transfer taxes, and other costs associated with the title. So what we're going to argue is that I'm going to pay you a buyout of what you would get if we sold the house. So if I was able to negotiate 8%, which I would want the amount to be higher, and the other side's going to say, well, it should be only 5%. Let's just say it's 8%. It would be $40,000 less. So I would actually buy her out 500 minus 40,000. It would be 460, and her interest from 300 to 460 is $80,000. So I would buy her out for $80,000. And that's why I've explained that in detail, is so that you understand how a buyout works and what is negotiated with your attorney and how you negotiate it within appraisal. Like you were saying, we even argue about appraisers and whether both parties want an appraisal, and we can get a third appraisal in certain situations. People negotiate all this because it's the largest asset, LeAnn, and it's the important thing, and it's an emotional time for both parties to get whatever amount it is. If it's a small amount, they may not do it. If the equity is a small amount, if it's a large amount, these issues do come into play.
For sure. So what happens if neither spouse can afford to keep the house?
That's when we have to sell it, LeAnn. That's exactly the factor that we do. And the other important thing is, if the parties don't negotiate a buyout or just selling it, or they don't, or if they don't agree to a use and possession period, or if we go to court, the only thing that a court can do is grant the use and possession period, or they will sell the house. The court cannot order one party to buy out the other party. The only two things that a court judge has authority to do is order the sale of the house or grant a use and possession period.
So, how about custody arrangements? How do those affect decisions about who remains in the home?
Well, that's a very important question. The only time the court grants a use and possession period is if they feel that one party gets custody. The person who gets primary physical custody of the child, okay, they then can grant the use and possession period. there's so many other factors to look at, LeAnn. Like, for instance, if one of the parties have a special interest, special needs child, and the house is, let's say he's a disabled child with a wheelchair, and the house is wheelchair accessible. Well, the court's going to think that it's very important for this child to have a use and possession period and have the child stay in the house. If the child is primarily being taken care of by one spouse, they would grant the use and possession to that party. But primarily, the party that gets primary physical custody, LeAnn, usually gets the use and possession period, gets the granting of the house.
And that makes sense. So, as we wrap up today's episode, can you just briefly cover the financial considerations someone should consider and evaluate before deciding to keep the home?
That's interesting you asked that question, because I wanted to bring that into how it's, besides all the other issues that are involved and how we connect the emotional issues that are going on, LeAnn, with the parties, and how the house is so important. The other part that we play a factor in as an attorneys is the issue of money. LeAnn, the thing is this: you have to understand that besides being able to afford the house on your own and the mortgage, you don't have the you have to be able to look at all of the expenses that you're going to have with one spouse. And you have to really consider, are you getting into a situation that 6 months after you decide to buy the other party out, that it's going to affect the children? And why I mean that is, there's been so many situations where I've had clients come back, buy out their spouse, and they're so happy because they get to keep it, but then they can't afford anything else. They can't afford to take the child out to eat. The child can't buy any gifts for their friends for a birthday gift. They can't go to the movie. The child is upset. The mother's like, I'm surviving. I'm paying the mortgage and barely meeting paying the utilities and moving forward. So we have to do what we call a long form financial statement, LeAnn. We have to explain to our client, if the client is buying the other party out, whether she or he can afford to do this, and that how it financially can affect your kids and their needs in the future, and whether it makes sense to keep the house. So it is very important to sit down, and I have a finance and economics background, and I'm a number crunching attorney, which other attorneys aren't. We really look at this and explain it. And you would be shocked, LeAnn, when I've sat down with a lot of clients and they sit down and look at what their expenses are and what they're going to be under a new mortgage, and whether it makes sense to really go down this new road of buying out the other party. And it is something that we do educate our clients on, not just besides educating them on what is the use and possession period and how it can benefit, but also the financial constraints of doing it too.
And I don't know about you, but we call that being house poor, and it's no fun.
It is no fun.
Well, that wraps up our episode of Conflict to Clarity in Family Matters with Rahul Kishore. If you have questions about the family home or other family law issues in Maryland, Rahul Kishore and his team at Shah and Kishore can help you understand your options and plan your next steps. Visit maryland-lawoffice.com to learn more and schedule a consultation. And remember to like, subscribe to the show, and share this episode with someone who might need it. Thank you, Rahul.
Thank you for talking with me today, LeAnn.
My pleasure.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.